Welcome to part 2 of a 3-part series on the structure of international investment agreements, also known as IIAs. This video discusses the substantive standards of IIAs. National treatment, the most favored nation clause, and the provision on fair and equitable treatment provide the standards of protections typically included in investment treaties. Investment treaties also contain specific provisions covering the preconditions for and consequences of expropriation. National treatment applies once a business is established. It's meant to provide a level playing field between the foreign investor and local competitor. By obliging a host state to make no negative differentiation between foreign and national investors when enacting and applying its rules and regulations, the position of the foreign investor is promoted to the level accorded to nationals. Investment arbitral tribunals analyze the national treatment clause was violated or not under a 3-step method. First, are the foreign investor and domestic investor placed in a comparable setting, or like circumstances? The measuring stick remains controversial. For example, does this mean someone in the exact same business? Or, not in the same business but in the same economic sector? Second, is the treatment accorded to the foreign investor at least as favorable as the treatment accorded to domestic investors? The social policy of a government measure has no bearing on the analysis of national treatment. However, fact of less favorable treatment is sufficient to show that national treatment was violated. It need not be shown that the less favorable treatment was motivated by nationality. Third, if treatment was less favorable, then is the differentiation justifiable? If rational grounds are shown, then the treatment may be justifiable. National policies made for domestic public interest can sometimes constitute a rational ground for according less than the national treatment, but which specific grounds are allowed is unclear. The most favored nation clause provides that the host state will give treatment no less favorable than it accords to investments of its own investors or to the investment of investors of any third state. The MFN clause ensures that the relevant parties treat each other in a manner at least as favorably as they treat third parties. The effect of the MFN in investment treaties is to widen the rights of investors. However, when applied in a mechanical manner, the effect may be to replace the negotiated substance of the treaty rather than to add an element of cooperation. While there was support for the view that the MFN grants a claimant the right to benefit from the substantive guarantees of other third-party treaties, the contemporary view is that investor-state dispute settlement clauses cannot be brought into the treaty in question via the MFN clause. The fair and equitable treatment is a standard that the legal systems of host states have to embrace in their treatment of foreign investors. It is the most relied upon and successful basis for IIA claims by investors. The FET language varies widely, but its source is from the customary international law of international minimum standard, which contains the traditional view that IIAs are protected against unacceptable measures of the host state by rules of international law which are independent of those of the host state. The function of the FET clause is to fill gaps, and it may offer redress where the facts do not support a claim for expropriation. It is generally understood that the FET provision represents a single, unified standard and that it is autonomous standard, that is, it is not an overarching principle that embraces other standards of treatment. The FET clause is distinct from the national treatment clause in that the FET standard may be violated even if an investor receives the same treatment as investors of host state's nationality. In practice, the FET standard is vague and lacks a formal definition. Since it is impossible to anticipate in the abstract the possible types of infringement upon the investor's legal position, the FET clause allows for an independent and objective third-party determination based on a flexible standard. The meaning of the FET standard will depend on the specific circumstances of the case, but investment tribunals will consider the willful neglect of duty, and insufficiency of action falling far below international standards, or even subjective bad faith. The most frequently cited definition of the FET clause comes from the Tech versus Mexico case. In light of the good faith principle established by international law, the FET standard is treatment that doesn't affect the basic expectations that were taken into account by the foreign investor to make the investment. The foreign investor expects the host state to act in a consistent manner, free from ambiguity and totally transparently so that it may know beforehand any and all rules that will govern its investments. The FET clause must be interpreted in accordance to Article 31 of the Vienna Convention on the Law of Treaties, which provides that a treaty shall be interpreted in good faith in accordance with the ordinary meaning and in light of its object and purpose. All investment treaties contain specific provisions covering the preconditions for and consequences of expropriation. Host states have the right to expropriate alien property. Treaty law typically addresses only the conditions and consequences of an expropriation. In fact, the host state's right to expropriate is unaffected by an international investment agreement. International law on expropriation has developed into three main areas. The first area concerns the interests that will be protected. The second area relates to the definition of expropriation, which is usually not a problem in cases of a formal expropriation, but may become a complex issue when the host state interferes with the rights of a foreign owner without a formal taking of title. The third area concerns the conditions under which a state may expropriate alien property. The burning question would be whether the legal title of the foreign investor has been affected by the host state's measure. Whether an expropriation has taken place is not always clear-cut. If a direct expropriation occurred for a public purpose in a non-discriminatory and prompt manner and followed with an adequate and effective compensation, then the expropriation may be considered lawful. However, investment tribunals are more likely to consider questions of indirect expropriation. This is when an investor's title is untouched but deprives the foreign investor the possibility of utilizing the investment in a meaningful way. In such a case, the host state denies the existence of expropriation and will not contemplate payment of compensation. Indirect expropriations are usually characterized by measures that do not involve an overt taking, but effectively neutralize the benefit of the property of the foreign owner. Creeping expropriation refers to a taking through a series of acts that eventually amount to having the effect of expropriation. Each step must have an adverse effect, but by itself, may not be significant or be considered an illegal act. Only in retrospect will it become evidence that those acts comprised part of an accumulation of harmful acts and omissions. The UNCTAD states that this form of expropriation is characterized by a slow and incremental encroachment.